Hello and welcome to the most peculiar fireside chat, in the sense that there's no fire, we're not next to each other, but we are virtually on the same stage, and I'm completely delighted to be here from rather gloomy London, and to be talking to two giants of the white-collar prosecutorial world. First of all, my dear friend Lisa Osofsky, who is the director of the Serious Fraud Office, and my new friend, Acting Assistant Attorney General Brian C. Rabbitt, who is going to be talking to us, or with me and Lisa, about their year and what's been happening since the last ABA event in London for the London White Collar Crime Institute. And we haven't got very long, so I've got lots of questions for both of them, and I thought we'd kick off, because we're both sides of the pond, as it were, here. I thought we'd kick off with cooperation. We know in the white-collar world that people are no respecter of borders, so can you help us with what's going on between the US and the UK in terms of cooperating when we all have similar but not the same systems? And I don't know who'd like to go first. Would you, Lisa, like to talk about cooperation between not just the UK and America, but generally what's happening, especially at this important part of our moment in our history?
Well, I think we've had an exemplary relationship with the U.S. Department of Justice under Brian's leadership and under the prior Brian's leadership. And of course, we are really excited about what we've been able to do together. We, as you know, have landed the largest ever corruption and bribery deferred prosecution agreement, working hand in hand with our French colleagues as well. And that's a real testament to how well we've been able to and continue to be able to cooperate. It's funny because we speak the same language, and yet the phrase "two countries divided by a common language" means that even if you do both speak English, you need to talk. And we make it a real point of talking on a very regular basis to foreshadow any possible issues, and also to ensure that we're speaking the same technical language. So for DPAs, as my colleagues here in the UK know, we've got a lot of judicial involvement. DPAs in the US don't have that same level of involvement, and we will have certain rules we've got to go by that we need to make sure we're very transparent with everybody else who is in on a case with us, so they know all the restraints and restrictions we operate under. And I just, in short, you know, we've got a lot of good cross-border cooperation. And Amanda, I know you made it broader, but maybe we could just start with us in the interest of giving Brian a chance.
Yeah, no, absolutely. I was going to ask Brian to come in now, actually, and just talk about it from your end. I mean, obviously, you two have the benefit of Lisa speaking two languages, so that's a good thing.
So Amanda, yeah, I'll comment as well. And first, I hope you can hear me. I'm having a little bit of an audio difficulty, so if I respond to the wrong question, that's why. But first of all, thanks for having me here today. Thank you, to Lisa, for joining me. In terms of cooperation, I think I'd echo exactly what Lisa said, which is it's a very important part of our program here at DOJ. International cooperation and coordination generally, and then specifically as it relates to the UK and in particular our partners at the SFO. I think that the cooperation that we've enjoyed with the SFO over the last several years, as Lisa points out, starts at the leadership level. My predecessor, Brian Benczkowski, and Lisa had a very strong working relationship. Lisa and I have known each other for a little while and have a strong working relationship. And that cooperation and coordination continues down to the line attorneys. It's been something that we've really relied on, and that I think has had a number of benefits for both countries in this space in recent months and Lisa mentioned, I believe briefly, the Airbus resolution earlier this year, at the beginning of the year, which, given the way 2020 has gone, seems like perhaps a decade ago, but was really just this year. That was a hallmark of our work together, as well as with French authorities. But it's not the only example, and it's not the only time we've worked together. It's something that we've enjoyed for a number of years now, and it's something that we look to continue to be a hallmark of our program going forward.
Well, Lisa, as you presaged, I mean, 31st of December, I'll be out of my office, and we will be out of the EU one way or another. How do you think that is going to affect not so much your ability to cooperate with your European partners, but on the ground? And you talked about it going from the top to the bottom. And obviously, in one sense, it's easy enough to pick up the phone to a colleague and have a great relationship. How do you think that's going to play out on the ground?
Well, I think I'm showing my original Midwest of the United States roots by the optimistic view, which is we're in law enforcement together. Brian and I want to make sure the bad guys go to jail and pay for crime. And I know Brian's not in the EU, but like all of us who are in this space, we're drawn by a keen sense of justice and wanting to make sure we do the right thing. And I think what that means is, for example, the head of the PNF who worked with us on Airbus is going to still take my call tomorrow or January 1, whether it's in or out with an agreement or not. We may not have certain tools at our disposal, but we will end up reverting back to tools that have worked in the past, bilateral arrangements, different cooperative arrangements across Europe. We have shown over time that we're a very good international player, even before we had, for example, joint investigation task force arrangements and some of the various things that may change. We're going to revert to the arrangements that have worked before. We're going to know that it's not going to be perfect. There are going to be some teething pains. I assume it's going to take a little while to get used to it, but I'm hoping that our very strong investment in overseas relationships with our European colleagues are going to really pay off for us and continue to pay off for us. And of course, as Brian knows, we rely on people outside the EU to be our good international partners as well, and we're going to continue to harvest those relationships with commitment and dedication.
Well, that brings me on to tell me, Brian first. Tell me your top 2 moments of the year professionally.
The top 2 moments of the year. I think to kind of make lemonade out of lemons, so to speak. I think the top thing for me really has been watching how our prosecutors here at the Department of Justice, how our personnel have pulled together and have really continued to do their important work, notwithstanding the unprecedented challenges that they've faced beginning in March and even continuing through now. I mean, the challenges have not just extended to kind of our ability to cooperate with partners like Lisa, but also to our more domestic work. Every facet of our operations has been impacted in one way or I have frequently said when speaking publicly that despite all that, we are very much open for business. We continue to advance our cases and we continue to resolve cases. And the reason for that, I think, is really due to the way that our line attorneys, our staff here have really pulled together. So, just that example, I think would be number one for me. And then number 2 would be some of the resolutions and some of the substantive work that I just alluded to. For example, over here in the United States, we pushed out quite a large stimulus package with a lot of short-term loans. We knew that there would be ripe opportunities for fraud with that. And so we stood up a program in the pandemic To date, in about 6 or 7 months, we've already charged 65 individuals with several $100 million of attempted loss to the federal government. That's something that we've done during the pandemic. It's something that I'm immensely proud of. And we've also continued kind of our regular work in addition to the corporate resolutions. We have a major focus in my section on healthcare fraud here in the United States, efforts to defraud the federal government and private insurers. I announced a couple of weeks ago the largest ever healthcare fraud takedown in the history of the Department of Justice. Again, those are cases that have all been investigated, charged, and brought, this year. So I think it's, again, just an example of the way we continue to do our job, notwithstanding the challenges that we've been facing.
Sure. I mean, it is interesting, isn't it? Just before I come on to Lisa, it is really interesting that even in advance of the measures that were being taken, certainly by our government, and just in terms of the most basic being lockdown and the terrible but inevitable rise of domestic violence as a result, or children at risk, that those were things that were immediately understood by governments and catered for, if you like. I mean, this is a terrible side of human nature, but it is good that people were ahead of the game on that. Lisa, what are your top two moments of 2019, 2020?
Well, I'm going to sound much less magnanimous and slightly more selfish person, because of course I agree with Brian that the teams and all this, of course. But I'm going to be, as I say, I want to focus on a couple of things that I was really excited about. One is that we were able to charge in the GPT case. That is a case that has been outstanding and in the works for many years. And the idea that we brought it to charge during this pandemic was a real accomplishment for the office. And I give full credit to the prosecutors who've been living with that case and pushing that case for years and years. I'd also like to point out that our most recent DPA, while not the blockbuster DPA that Brian and I worked hand to hand with, but G4S is a case that had a lot of notoriety in this jurisdiction. It involved some fraud as opposed to corruption, which was Airbus, fraud in electronic tagging. And one of the features about the resolution of that case, shout out to the Department of Justice, because we had working on that case a secondee in our office who was with us for a couple of years and did yeoman's work on that case. And we were able to really put teeth into that DPA and move the evolution. Remember, it's a newer tool for us in the UK, and to really put forth the kind of requirements and oversight that we thought was very important in that particular case. So those are accomplishments I really am proud about, and I give full credit to the case workers and case controllers and everybody who worked on those matters.
Lisa, you make a really good point about DPAs and their evolution. And I particularly know that because I'm looking at the chapter I'm doing on sentencing in corporate crime at the moment, and DPAs obviously are not quite sentencing, but they're parallel to it. And I mean, one of the things that's changed over the years that we've had DPAs here is the maximum credit. But also, I think for the first time in the G4S, you've got what's called a reviewer. So similar to, not quite the same as a monitor, but just tell us about that, how that has sort of come to being here, because monitorships are very, very frequent, aren't they, in states? Not so here. So just help. I mean, I know something that's close to your heart historically.
Yeah, thank you. And I'm sure Brian can speak to the frequency and the appropriateness of monitorships now in the U.S. under his leadership. And in our case, we are very conscious. We've got rules that we work with where a monitor is a very specific kind of animal. We did not seek a monitor in this case, but we did something different. As Amanda said, had a reviewer, and that is reflects the maturity of the company's compliance program as we found it. So, this is very much a case-by-case kind of determination. And we saw in this case a company that we thought would benefit from having a more involved body that would give reports to the SFO about where the company was headed in terms of observing its obligations under the DPA. So I realize that's news here. We really haven't used that sort of tool so much in the past, and yet it's a tool that can work when the circumstances require it. And it was, I think it was exactly the right move for this particular case. It doesn't mean that we've had a sea change and we're always going to seek that sort of resolution. It means that for this case, at this time, it was appropriate, and we're very, very thankful that we came to that resolution and that we were able to do it in a way that will protect our country and our economy and make sure that, it's very much in my sights that we want companies that are operating in accordance with the law, especially in the wake of what we know has been difficult circumstances with the pandemic. We know that the tumult that, we know the difficulties that our countries can face. For us, it's absolutely critical to make sure that we are helping our economy and helping our companies here be good corporate citizens. And that's exactly what that G4S DPA was designed to do.
So as far as the, we seem to have lost Brian temporarily, so I'm going to stick, actually, if I may, with you. Do you?
I can hear you.
I think he's there.
Are you there?
You look there to me.
Oh, okay.
I can hear you.
You're there.
You may not be.
I just, it just says I can't see or hear you. But anyway, if you can hear me, that's perfect. What I was going to ask, Brian, is are monitorships, are reviewers a genuine success, or are they just another financial penalty for the corporate?
Well, it's a good question, Amanda. Monitorships are obviously something that's received quite a bit of attention globally and here in the United States in recent years. I think our position would be they're never a penalty, and they're never intended to be a penalty. They're intended to be rehabilitative. And I think we try to be both transparent about when we'll consider imposing them, and we try to be judicious about when, in fact, we do impose them. You can look to a couple of our recent examples, recent resolutions in the spoofing and market manipulation cases as an example. The JP Morgan case, which we resolved fairly recently, was a very large case, wide scale misconduct, but we didn't require a monitor. One of the reasons why was because we made a comprehensive evaluation of the company's compliance program at the time of the settlement, at the time of the resolution, and we determined that it wasn't needed, it wasn't necessary under the circumstances, due in large part to the significant investment that the company had made since the time of the alleged misconduct to the present in terms of a compliance uplift. And so we had some confidence that their program was, in fact, in good shape. You contrast that to the Bank of Nova Scotia, the Scotiabank resolution. Again, similar conduct, not nearly as widespread, but nevertheless serious. We did impose a monitor there, a 3-year monitor with reporting obligations. Part of the reason why was, again, our assessment at the time of the resolution as to what we perceived to be continuing inadequacies with respect to their compliance program. So I think those two cases present bookends on the spectrum, and I think they show how we approach this. We try to be not reflexive in terms of when we'll require a monitor, but rather judicious. We try to analyze the compliance program as it exists now, and we try to determine whether a monitor is something that will actually have a beneficial effect for the company, and as Lisa says, for the market, for the country, and help the company become and ensure that it remains a good corporate citizen going forward.
So, Brian, I mean that's interesting what you say, because I'd like Lisa to tell us how it plays out here generally, because my understanding, if one looks at the DPAs here, is that very often what you find is that part of the demonstration that this is a company that is suitable for a DPA is in effect that they've mended their ways. And so they've demonstrated that they've moved beyond the criminal conduct, probably, that means that they are suitable for a DPA. And that in itself would tend to suggest, certainly I would suggest in our jurisdiction, that that's not going to be a corporate that needs a monitorship. What's your take on that, Lisa?
Well, I'd say, have you heard the phrase trust but verify? I mean, there are certain situations where, remember, these are corporates that have signed off on a statement of facts, agreeing. They've come into open court and agreed that they've committed illicit actions. And, you know, a reviewer doesn't necessarily, well, let me back up. As we know, there are a lot of different factors that will be in play as to whether we agree and think that a DPA is appropriate in a particular circumstance. If you've got, remember, a reviewer can have any number of jobs. In the case of G4S, we have a reviewer who's going to be ensuring that there are certain structural changes made within the company, that there'll be certain reporting lines and certain jobs that will be part of the oversight infrastructure. That doesn't necessarily mean that that's a company that wasn't willing to step forward, admit its guilt, to talk about, to put in place certain compliance procedures. But compliance is partly reflects, it's an evolution. And so there may be a more or less mature compliance structure that we find. It doesn't mean there can be any number, you know, you could have had a whole different board, and yet if you still don't have all of the people in the right chairs overseeing the new regime, that we may need a little more comfort and a little more of an oversight in a particular case. So I'd say, you know, it's not that you get a DPA if you've got you've made perfect reparations, everything's wonderful, and you move on. That's rarely will you find. I've been in enough corporates and financial institutions to know that is not a mark that you often meet. We can always get better. And the question is, what sort of processes do we need in place to ensure that that company that has agreed and admitted its guilt, made reparations, went through a cleansing process, put a lot of the right processes in place, what more needs to get done where we would want a more of a view about it. And I think those are similar considerations that we thought about in the various monitorships I've been involved with. And it's not so dissimilar, even though it's a different regime, from what I heard Brian say just a few minutes ago when he did the bookends of the two very different companies that were both given a DPA, but looked at differently in terms of what sort of oversight was.
I mean, I think DPAs by their very nature are very fact sensitive. What are it? Both, I imagine that's equally true in the States. You need to look at what the facts of the conduct are, the responsibility, and what the corporate structure is going forward, in order to work out what are the terms that need to be part of the DPA. We're running out of time horribly quickly, and I've got some curveballs, and I definitely don't want to not throw them at you. So let me just I've got some others that are just totally normal questions, but I'm going to fling those out, and I'm going to stick with the curveballs. So tell us, you get off pretty lightly because you only get time for one. What's your worst thing of the year since October 2019? Brian first.
I think it would have to be the investigative challenges that we face, just kind of, sticking to staying in the professional. It's really just been the challenges. I mean, we in our international work, the work that we do with Lisa and her team and other foreign regulators, I mean, we depend on travel. It's often good to be face to face with folks, to be in the same room with them. And then as we work up our cases, we depend heavily on, interviewing individuals, getting an assessment of their credibility to move our cases forward. Obviously, that's just not something that's been that we've been able to do over the course of the last year. We developed workers for a lot of our cases and a lot of our witnesses using platforms, but this one, platforms where obviously there are some witnesses that are too important, don't lend themselves to virtual interviews, so we've had to postpone the. That's just one example. There have been innumerable challenges in terms of our cases, fact development, charging, trials. Frankly, we've had a couple of trials recently, and we've had success there, both in carrying the trial out in terms of the verdict. But again, we have a tremendous backlog of cases that need to be tried for a long time. So, professionally, that's probably the single worst thing that would be.
What about you, Lisa?
I'd say we face all that. It's actually good to hear that not misery loves company, but it's in, of course, these are happening around the world, and it's good to know that our partners are facing some of the same concerns we are, so that we're not the only ones who are making life difficult, as it were, or facing these issues. But if I can just point to one case where I was recused, so it wasn't really anything I was involved with, but I think, and this one didn't happen, the two events within the same case, if you'll give me that.
I will.
One is I sat, as I say, on the sidelines. I was recused, and I watched the Barclays case come through court, and I made the grave mistake of making a dentist appointment one morning, thinking, when the jury first went out, I thought, well, that's a case that went on for weeks and weeks and weeks. The jury will be out for quite some time. And by the time I got back from the dentist, and it was all of, I think, 10:05 or something like that, when the jury had been out since 10 o'clock, the jury had already returned a verdict of not guilty. As a prosecutor, if your jury's out for 5 minutes, it probably isn't a win for the prosecution. So that was one of the first things. And the other within that same case didn't happen next year, but when I was recused, but when I learned that, frankly, other case, when my Rolls-Royce defendants turned out to be dead, that was also not a good day at the SFO, is learning that the very people we were meant to go after as individuals who had already been in the company had been involved in a DPA, we were then looking to charge individuals, and the majority of them were no longer alive and well. So that was another bad day for me. And
it was a pretty long investigation.
Yes, it was, without from an individual's, it was a very successful case brought by David Green with a very, at the time, a groundbreaking DPA resolution. But obviously it was disappointing to me to find that the defendants were not alive any longer.
I suspect it was for them too. So just again, I'm going to squeeze in a couple more questions, because I feel that, frankly, we were a bit shortchanged at the beginning. So tell me, how important is it, before my final curveball is coming soon, but tell me, how important is it to you both to liaise with the defense community in terms, obviously you're going to say very, but what is it that the defense community gives to the work that you're doing from your perspective? Brian, can you help us with that?
I can, Amanda. Yeah, I think there's two principal ways. There's obviously a number, but two principal ways come to mind. The first is, here at the Department of Justice, we have a great tradition of political leadership coming in with different administrations to sit on top of the criminal division and various U.S. attorneys' offices in leadership, supervisory roles. I think it gives a good outside perspective. Many of those folks have backgrounds in prosecution. but they've also, in many cases, been out in the private sector for some period of time. I think it provides a good check and a good perspective on how things are working from the outside. And keeping that in mind, we also take into account, this is the second thing I wanted to mention, how the defense bar is reacting to and is working with the policies that we've put out. One of the things we've tried to do quite a bit over the last couple of years is be very transparent, to publish policies, publish documents that kind of explain how we go through various analyses, from selection of corporate monitors to corporations that are claiming an inability to pay. When we put those things out, we solicit and take feedback from the private bar quite regularly. And that leads us often to revise or update various policies. For example, we've revised our guidance for the evaluation of corporate compliance programs, I think once every year for the last 3 or 4 years, at least. That's been done in large part based on feedback that we've received from professionals and from the white collar bar. So it's something we certainly take into account, and it provides us with a strong perspective.
And Lisa, what about from yours?
I think we feel exactly the same way. I think the quest for transparency, I know the first policy we put out under my leadership was about cooperation, what it means to cooperate. And there was a whole history of litigation around privilege, LPP privilege. And we wanted to make sure we didn't take a stance that was going to be anathema to many of our colleagues in the defense bar. And we worked closely with, it was primarily Amanda, your predecessor, and Simon Davies in the representing solicitors, but we were really keen to make sure that we took views before we came out with something that, especially in a contentious and fraught or difficult, an area that had been difficult. So I think a lot of what Brian says just very much applies to us. Some of you here will know that we had Peter Pope, who had come from being global head of investigations at Jenner. He came in-house with us for a year and helped our folks get used to some of the ideas that he brought, both from prior public sector work and also his private sector work and his experience on the compliance side. So we've really benefited greatly from interacting with members of the bar and solicitors who've had a different experience. And we do welcome some of our most successful colleagues now come from the private sector, and we're just so grateful to have their perspective on our cases. We listen, we hear them, we shape our work based in part around what they're telling us, and it always makes us stronger.
Right, so I think I really am going to have to wrap up in a minute, but before I do, I'm just going to ask you something which is a bit more personal. So I would like to know, and I'm sure the audience would, what how you got to where you got to. I would like two pivotal decisions or moments in your life that you can pin where you are now onto, and you've only really got 20 seconds each. 10 for each. Lisa, you go first.
Becoming an AUSA rather than going to a law firm out of a clerkship. And so getting cutting my teeth, first real job out of clerking, depending on where you sit, being a federal prosecutor, and coming to the UK as a secondee for the very same attorney general that Brian serves now. I was sent to be a secondee at the SFO many years ago, and that started a lifelong love for this country and a fascination with the British legal system, and I feel very grateful for both opportunities.
Fantastic. Beat that one, Brian.
I'll be succinct. I'll just say dumb luck is how I've ended. No, I think, look, I can point to kind of two decision points in my career. In 2016, 2017, I was very happy in private practice, just kind of focusing on complex civil litigation and white-collar investigations. When the president won and I had the opportunity to join the administration, it was a big challenge, a big decision for me. I have a young family. I had a good career, but I took a risk and I joined, and I've had a set of experiences that have been very rewarding and have allowed me to engage in public service in a very meaningful way, I feel. So it's been good. And then the second was when the General was nominated in the fall of 2018. He's somebody I've known for a very long time. He asked me to come over with him and be his right-hand man, so to speak. I had another position in the administration with the chairman of the SEC at the time. I was very happy with that. It was a great job. I was focusing on enforcement work, but again, took a risk, moved over and helped the Attorney General transition and get his leadership team set up. And here I am today. So again, like Lisa, it's kind of critical career decisions along the way where you take a risk, where you do something a little different. But I think so far it's paid off.
Fantastic. Well, I don't think we can end on a better note than that one.